Good morning, everyone. Welcome to the Infinity Fast Forward webinar series. We're very happy that you all have taken some time to join us today. My name's Steve Kessler, and I'm going to host the program today. We have some pretty important information to pass on. I think that's obvious by the number of people that registered for this webinar. Today, we're going to talk about some changes coming to the medical certification reporting process, something that's soon to go into effect. So we've decided to bring in our best expert to do that. We have Brandon Wiseman from TruckSafe, and they're all about DOT compliance. But before we kind of kick things off, let me pass on a few housekeeping items. Obviously, we can't hear you. Everybody is muted. So if you have a question or a comment, feel free to use the chat feature there to ask a question or pass on a comment. You can also use the little Q&A box down there if you choose. So if you want to communicate with us, that's going to be the best way to do it. And we're going to try to go through the presentation because we're going to touch on some Q&A at the very end of the presentation that may answer some of the questions that I'm sure y'all are going to have. So we'll try to hold the questions toward the end. We try to keep this program to about an hour. So just be mindful of that. If we don't get everybody's questions answered, we'll do our best to reach out to you and try to answer those for you. Let me by the way, why don't you all just jump on the chat and let us know who you are and who you're with and where you're from, so we kind of have an idea who's out there this morning. And while y'all are doing that, let me introduce Mark Ray. Mark's my co-host here. If y'all have joined our webinars in the past, Mark's an industry veteran at an executive level. He's a certified director of safety, still holds a CDL, and is involved in a lot of advisory capacities in a bunch of different organizations around the country. So our guest today, I think probably a lot of you may know Brandon. Brandon is the owner and president of TruckSafe Consulting. He's a transportation attorney and a partner with Childress Law. And Brandon, his organization has assisted some of the nation's leading motor carriers in developing and maintaining compliant and cutting-edge safety programs. He has also represented carriers of all types and sizes before the FMCSA on matters such as safety rating upgrades and civil penalty proceedings. Through his consulting company, Brandon now offers carriers state-of-the-art compliance resources and regulatory training materials that cover a wide range of safety-related topics. And Brandon's also a regular speaker at industry events and a contributor to a number of industry publications. So we're very happy to have an expert on this today. So Brandon, with that, I'll let you take it away, sir.
Well, thanks, Steve and Mark and all the Infinity folks. Really appreciate the opportunity to join you once again. And thanks to everybody who tuned in today. Like Steve said, big crowd. So topic seems to be a pretty popular one among folks for obvious reasons. It's one that, has a deadline coming up, or an implementation date, I should say. And so from my vantage point, I've seen a lot of confusion over what exactly is changing, a lot of misinformation out there. So hopefully we will be able to clear up some of that today throughout this presentation. And as Steve said, as we go along, if you have any questions, throw them in the Q&A box and we'll try and get to them at the end. We've got an FAQ section at the end. So we in the work that we do for fleets, we have already gotten and fielded a ton of questions on this particular topic. So I've kind of gathered those into an FAQs that we will discuss at the end. So that may address some of them, but certainly drop them there in the Q&A box if you got them, and we'll spend some time on that as well. I think the best way to tackle this is to first level set here with some regulatory backdrop, why it is that things are changing when it comes to medical certification, the process for CDL drivers to get medically certified, and how that information gets exchanged with their state driver's licensing agency. That's essentially what is changing. But I think it's important we first take a look at why things are changing, what prompted these changes. So we'll spend a little time here with the backdrop, and then we'll move into a discussion of what exactly is changing and when. And then we'll talk about what is not changing. That's where a lot of the confusion seems to stem, at least from my perspective. And then I'll offer you some of my recommendations for what they're worth, some of the things that I can envision going wrong if things don't play out as expected. So I'll offer some tips there, and then we'll end up with those frequently asked questions before we open it up for more broad questions. So that's how we'll tackle it. So looking first then at the regulatory backdrop against which these changes are happening. As most of you are hopefully familiar, the FMCSA and its predecessors, the agencies that regulate interstate trucking and intrastate trucking to some extent, we'll get to that a little bit later, have long required that regulated drivers be physically qualified to operate the vehicles that they operate, and for good reason. Obviously, when we've got drivers out there operating up to potentially 80,000 pound or more vehicles on our nation's highways, we want to make sure they're not going to incur some kind of disabling medical condition while they're on the road and end up causing a catastrophic accident. So for that reason, dating back to, almost a century at this point, the motor carrier safety regulations as they exist now and as they have existed in the past have contained some type of physical qualification standards, minimum qualification standards for drivers. As they are now, these are codified in Part 391 of the Federal Motor Carrier Safety Regulations, which is where you'll find all of the driver qualification requirements for interstate federally regulated commercial drivers. Those rules, the physical qualification standards, like other components of the FMCSRs, have changed here and there over the years. We saw the most significant change to the physical qualification standards back in 2014. You may remember this if you were, around in a safety or compliance type role back then, but this is when the FMCSA took the actions to stand up what is called the National Registry of Medical Examiners. And this was an initiative that was kind of spurred by some rampant fraud that we had in the industry and still have to some extent, unfortunately, which was, drivers or nefarious carriers or other actors in the industry trying to get around these physical standards, in essence, in various ways, namely falsifying their med cards so that it looked like the drivers were physically qualified. They would, manufacture a doctor's name, and they would just write themselves a med card and they would present that to the carriers. So to get a hold of that issue and to hopefully alleviate or get rid of it from the industry, the FMCSA stood up this kind of central database of certified medical examiners, the doctors and the chiropractors and the physician's assistants and the others who perform these medical exams. They have to be registered with this National Registry of Medical Examiners. And in order to be qualified under the qualification standards of Part 391, a regulated driver has to go visit with one of those certified medical examiners on a certain cadence. At most, or at least every 2 years. And as many of you will know, sometimes just kind of depends on the driver's health conditions. It could be even more frequent than that, depending on, if they got high blood pressure, they're going to have to go more regularly to these certified medical examiners and go through the physical examination process and then be issued essentially a certification that they meet these physical qualification standards. So we rely on these medical professionals who are now certified in the FMCSA's National Registry of Medical Examiners to perform these physical examinations of our population of regulated drivers, and then to issue those drivers the certification that they need as evidence that they are physically qualified. Now, it's that certification process The manner in which drivers are certified and that their certification is published to those who need to know about their certifications, that's what's changing, effective at the end of this month, June of 2025. But it's not as if this is something that has just sprung up on us. This was planned for. This upcoming change, which we're about to get into, was the original design that was implemented back in 2014 and in 2015 when the FMCSA first stood up the National Registry. They had originally envisioned this process that we're about to have. So in 2015, you may also recall FMCSA, in addition to standing up that national registry, this is when they also standardized the med cards that the drivers get, that regulated drivers are issued as proof that they are medically certified. Before 2015, the specific form on which those medical exams or certifications had to be documented could vary from doctor to doctor, state to state. But in 2015, FMCSA standardized that. And so now all regulated drivers are issued a particular form. And it's right there listed in the third bullet point, Form MCSA 5875, which is what we colloquially refer to as a long form physical examination form. And then also the MCSA 5876, which we call our med cards or medical examiner certificates nowadays. These are the MEC, the medical examiner certificate in particular, is the little card that the drivers have been carrying with them typically for many years now. This is what they usually have with them in the trucks as proof that they are physically qualified, that they turn over to officers when they are stopped for roadside inspections, that they give to you as motor carriers to keep in their driver qualification files. We're familiar with this process now, having lived with it for about 10 years, right? And so since 2015, that med card has served as the standardized proof of a regulated driver's physical qualification. Now, the transmission of these certification results has, since 2015, been a little bit different for CDL drivers versus non-CDL drivers. So if you're a mixed fleet that has both CDL and non-CDL drivers, you're probably painfully familiar with the distinction between the two when it comes to how the results from their physical examinations are handled. So for CDL drivers, again, since 2015, the rulemaking had originally envisioned an electronic transmission of that CDL driver's physical examination results from the medical examiner, the doctor or whoever's performing the medical exam, to the National Registry, that centralized database that FMCSA has set up for all medical examiners, and then from that registry to the state driver's licensing agency. It has envisioned that type of process, that type of electronic process since 2015. But, and this is the big but, that process has been delayed several times over the past decade, due primarily to technology issues, and even more specifically, issues with state driver's licensing agencies getting their act together to get a system in place that can accommodate this type of an electronic transmission of these physical exam results. So in light of those technological difficulties, the FMCSA has had to make some concessions. They have had to delay this electronic process, and they have had to allow temporarily the process that we are now familiar with for the last decade, which is an interim step. And so as it stands currently, this is the current process in most states. I will make a caveat here to say that some states have already implemented this electronic system and have been using it for a while. Texas is one example. And so if you're in a state that has been doing this for a while, then maybe nothing is changing. But I'll point out some things that probably still will be changing for you here come the end of June. But in general, that process, if your state has already adopted a system like this, the general process won't be changing. But for most states in the country, they have not adopted that system yet. And so this will be a pretty significant change. But here's how it has been working over the past 10 years or so. So for CDL drivers only, remember, there's a difference between CDL and non-CDL drivers. I'll talk about non-CDL drivers here in a minute. But for CDL drivers specifically, The regulations currently require medical examiners to issue those drivers physical med cards, that form that I mentioned, and for the CDL drivers to physically take those med cards to their state driver's licensing agency once they get it, to then associate that certification with their driver's record. So if I'm a CDL driver, I get medically certified by a certified medical examiner. I have to physically get that card, take it to my state driver's licensing agency, and make sure it gets associated with my license. And then the second part of that is then my employers. So any employers, motor carriers of CDL drivers, they can accept from that driver that physical med card as proof that that driver is physically qualified. But here's the catch, and this is something that still, even after 10 years, motor carriers, in my experience, still struggle with understanding. And it's not surprising because this is tucked away in the regulations if you dig in there. But the regulations say that getting that physical med card from your CDL drivers is fine, but it's only fine for a period of 15 days after that med card was issued. And that's proof that they are medically certified, but only for 15 days. So what happens after the 15 days? Well, the regulations currently say that after 15 days have elapsed since the date that the driver was issued that med card, you as their employing motor carrier are supposed to be currently running a new motor vehicle report, MVR, on those drivers and making sure that they had done what they were required to do, take it to the state, and that the state associates it with their license. So when you run that new MVR, ideally what you see is that new medical information matching up with the physical med card that they have. And then that MVR that you run is now your proof that that driver is medically qualified. That's how it's supposed to run currently. We call these 15-day MVRs colloquially. And what we find is that when we do our assessments for our motor carrier clients, and also when we're helping motor carriers through real DOT audits, we find that a lot of carriers are not doing these 15-day MVRs for CDL drivers. They don't know that it's a thing. They're just running their annual MVRs, and they don't realize that every time one of their CDL drivers gets a new med card nowadays, they're supposed to run a new MVR within 15 days of that, in addition to that annual MVR that they're running. So this is a big gap for a lot of motor carriers. And hopefully, with these changes I'm about to talk about, we will get away from that particular gap and we'll have fewer of those violations. But in my own anecdotal experience, that runs a lot of carriers into trouble in the context of a DOT audit. So, but anyway, that's how the process works currently for CDL drivers. Now, what about non-CDL drivers? I mentioned that the process is different. Well, the process is different in the sense that non-CDL drivers, like CDL drivers, again, and I'm talking about regulated drivers. So these are drivers subject to the Federal Motor Carrier Safety Regulations, which generally for property carriers includes drivers of vehicles or combinations that exceed 10,000 pounds if we're talking about a property carrier. So not very difficult to exceed that weight threshold. And also to drivers involved in intrastate commerce who are subject to their state's adoption of these qualification rules. And most states in the country have adopted them. Just the question is at what weight threshold in the particular state. But the point is here, the process for non-CDL drivers is that they still have to be physically qualified and they still have to be examined by a certified medical examiner. And they too are issued a physical medical examiner certificate, a med card, and they must provide a copy of that to their employing motor carrier to keep in their DQ file and also keep a copy of that on with them while they are operating their commercial motor vehicle. So the difference there between them and CDL drivers is that there's not that MVR component that's required for non-CDL regulated drivers. If you're a non-CDL fleet, you can ignore that discussion that I just had about the MVRs. Your proof that your non-CDL regulated drivers are physically qualified is their physical med card that they present to you and that you keep a copy of that in their driver file. So that's the big difference currently. Many problems with this interim approach to how we handle medical certification have arisen over the last 10 years. I've already mentioned this first one, which is that many carriers are unaware of that 15-day MVR requirement, and that's leading to critical level violations in audits and potentially leading them to downgraded safety ratings. So I've lost count of how many fleets I've helped that that have encountered that issue and have found out the hard way that that is a requirement. Some other problems that are present with this interim process. Drivers failing to take their med cards to their state driver's licensing agency. They get the new med card and they think they're good to go, but that's, of course, not the end of the process. As I mentioned, they're supposed to take that to their licensing agency, and for whatever reason, they don't. Maybe they're busy and they can't get to the licensing agency. Maybe the licensing agency is backed up. Whatever the rationale is, a lot of drivers just fail to get there, and then and I'm talking CDL drivers specifically. Again, non-CDL drivers don't have to do that process, but CDL drivers failing to take it to their state driver's licensing agency then just ends up with that new medical information not getting associated with their license, with their driving record, and then the state initiates a downgrade of their CDL because they think that their medical exam has expired. And so what we end up with not only are problems in audits, but also problems roadside for these drivers and the motor carriers that employ them, because the way that that plays out is, for whatever reason, the new medical examination doesn't get uploaded to that driver's record. State initiates actions to downgrade their CDL to a standard operator's license. Driver doesn't find out about it, or he finds out about it and he ignores it and he continues to drive. And then inevitably, once he or she gets stopped for roadside inspection, the officer is going to very quickly see that, hey, their CDL is downgraded and they're not authorized to operate this truck. Now they're placed out of service roadside, and that jacks up your driver fitness score if you are a motor carrier with CSA scores. And then also, not to mention the problem that we have with several states being slow to upload these drivers' results or their new medical examination and associating it with their driving record. This was a huge problem early on in the process. It still is a lingering problem in many states where the states are just slow to get it uploaded. The driver has done what they are supposed to. They present the new med card to the state driver's licensing agency, but then the state agency takes their sweet time in getting that associated with the record, and then the previous one expires, and then we're in that same sticky situation. So lots of problems stemming from this current temporary process through which we are transmitting driver examination results. So that's those problems are in part why we are moving away from that system and to the new system that was envisioned from the start. So that takes us to what exactly is changing and when. So here's the date here highlighted. Effective June 23rd of 2025. This is a date that has been pushed back time and time again, but this is the date that is currently slated for this change. And, I don't want to say that it's not possible that the FMCSA could push this back even further, but it's unlikely, in my opinion, at this point. We are only a couple of weeks out from this. And so you have to plan as if this is going to take effect on June 23rd. So effective June 23rd, 2025, here's what's changing. We're going to that process that FMCSA had originally envisioned, which is that we are taking out the middleman in that transmission process, which is the driver. So now when medical examiners issue a driver, a regulated CDL driver, that's the important part. When a medical examiner issues a new med card or medical certification to a CDL driver, they must now electronically upload that result to the National Registry of Medical Examiners. Then the National Registry will take the responsibility to notify the appropriate state driver's licensing agency. So if the driver is domiciled in Indiana and he gets a new med card that gets uploaded to the National Registry, then the National Registry is going to alert the Indiana BMV that driver has a new medical certification. And then the state driver's licensing agency is going to take that information that is electronically transmitted to it to update the driver's CDL record with the new exam details. So what was missing from that new process is the requirement that that CDL driver physically present that med card to their state driver's licensing agency. CDL drivers are no longer, effective June 23rd, 2025, going to have to present their physical med card either to the carrier or to the state driver's licensing agencies. So that's the big change. So one of the big questions that a lot of fleets have is, okay, what's the timing? How does that play out from a timing perspective? Well, here's unfortunately the FMCSA's rule on this is not as clear as it should be, and so this is how I read the rule to look, and this is how others read the rule to look that I follow. I think this is how it's supposed to play out. The last bullet point here on the timing is the one that's a little confusing if you just go read the rule itself. But I think we have enough evidence from the FMCSA that this is the correct timing. So first of all, what we know is that effective June 23rd of 2025, when the medical examiner issues a driver, a CDL driver, a new medical certification, they have to upload that result to the National Registry by midnight of the following calendar day. So if the driver gets the certification on a Friday, then by midnight of Saturday, the medical examiner would have to get that uploaded to the National Registry. It's a calendar day. Then, once the National Registry has that information, the FMCSA says they will, quote unquote, promptly notify the state driver's licensing agency. We don't know what promptly means. Hopefully it means immediately. I don't know what would cause a delay in that. If we have systems that are supposed to be talking together, I don't know, once it gets uploaded to the National Registry, I don't think it's going to require physical eyes from the FMCSA to look at it and do something with it. It should just exist in the National Registry for the appropriate state driver's licensing agency to then pull down. I think that's how it should work. So National Registry will promptly notify the appropriate state driver's licensing agency. And then once the state driver's licensing agency has that information, they are supposed to, within one business day, then update that driver's record. So assuming promptly means immediately in that middle bullet point, then at most, what we should have is a process that takes 3 days, right? And I say at most because it would be a weekend issue that would cause it to run into 3 days. Normally, it would potentially be 2 days, right? So because the state driver's licensing agency has a business day to get that new exam result associated with that driver's license, that's what would cause the delay, is if there's a weekend involved. But note that the medical examiners have a calendar day to get their information up to the National Registry. So here's the summation of the old process versus the new process, a flow chart, if you will. So the old process, just to sum this up and to be perfectly clear, the process that we are currently using and have used for the last 10 years, medical examiner issues a physical med card to the CDL driver. CDL driver takes the med card to their state driver's licensing agency. Licensing agency updates the driver's medical certification status on their CDL driving record, and then the carrier runs a new MVR to verify that that information has indeed been associated with that driver's license, and the CDL driver keeps a copy of that med card in their possession. That's the current process. The new process, effective June 23rd, 2025, medical examiner uploads the exam results for the CDL driver electronically to the National Registry by the end of the next calendar day. National Registry promptly alerts the state driver's licensing agency of that new driver data. That state licensing agency then updates the CDL driver's record by the next business day. And then this part's not changing. The carrier, the employer of that CDL driver, still has to run a new MVR to verify that driver's status, physical qualification status. They can no longer, effective June 23rd, accept a physical copy of that driver's med card as proof of their physical qualification status. That's an important point. Just getting a physical copy of the med card from the driver anymore will, effective June 23rd, not be sufficient evidence of their physical qualifications. It has to be an MVR that the motor carrier runs. In fact, this is a frequent question we get. It's in the FAQs, but I'll go ahead and mention it here. Medical examiners, effective June 23rd, are no longer going to be even required to issue CDL drivers a physical med card any longer. Now, FMCSA has some guidance to them that says if the driver requests a physical med card, they should give it to them. But as a matter of course, the medical examiners are no longer going to issue physical med cards. It is a electronic process going forward. And so the important point there is that even if a CDL driver happens to get their hands on a physical med card, that is not sufficient proof of their physical qualifications. It's the driver's driving record that is the official proof that that driver is medically certified to operate. All right, so that's what's changing. Well, what's not changing? Equally as important as what is changing. What's not changing, the medical exam process for non-CDL regulated drivers is not changing. Non-CDL regulated drivers will still be issued physical medical examiner certificates, the physical med cards. They still must provide their employer carriers a copy of those med cards, and they still must carry them on their person when they are operating a commercial motor vehicle and present those to law enforcement as proof that they are medically certified. So process is not changing at all for non-CDL regulated drivers. Also not changing is the self-certification process for CDL drivers. This is the process where when they're getting a new CDL for the first time, or renewing an existing CDL, or upgrading a CDL, or adding endorsements, when they have to self-certify their status with their state driver's licensing agency as either accepted interstate, non-accepted interstate, accepted intrastate, non-accepted intrastate. They have to tell their licensing agency, essentially, am I operating interstate or intrastate, and am I accepted from the medical qualification standards or not? They have to self-certify themselves. And so that process is not changing at all. Something else that's not changing is, the fact that carriers, employers of CDL drivers must be running MVRs to check on or to verify the CDL driver's medical qualifications. Copies of those MVRs need to be kept in their DQ files as proof of those physical qualifications. So you still have that process, you still have that requirement. It's just effective June 23rd, you no longer have that interim 15-day period where you can accept just their physical med card as that proof. Now it's only the MVR that will serve as that proof. So you're probably going to need to put new processes and procedures in place to make sure you're running those new MVRs and that you have that MVR showing their new medical certification information before the expiration of their last med card, or otherwise you're going to have a gap of time there where their old med cards expired and you haven't yet run a new MVR. And if they're out there operating in that interim gap of time, then that's a violation on your part. So you need to make sure you are informing your drivers. This is a recommendation I'll make here in a second, but I'll say it here. You need to make sure that if you're a carrier, you are informing your drivers of this new change and that you're getting them to go get their new medical exams, probably even a couple weeks earlier than they would have normally under the current rule, just to make sure this all plays out, especially starting June 23rd and for the 1 month, 2 month, 3 months after that implementation date. There's going to inevitably be some growing pains with this. So drivers whose med cards expire in that time frame, there's going to be some trouble. So best to get them in as soon as possible to get their new med cards so that we can avoid issues with this kind of transition period. So with that said, here are some recommendations for your consideration. Again, first and foremost, carriers should ensure that their drivers are familiar with the new process and requirements. Again, CDL drivers specifically. Things are not changing for non-CDL drivers. I don't know that you need to let them know about changes. But for CDL drivers, if you're a CDL fleet, you need to get some information out to your drivers about what exactly is changing, how the new processes will work, and probably some tips for them to keep in mind, which I'll get to in a second, when they are going to get their new medical certification, some things that they will want to have running through the back of their mind while they're there physically in front of the medical examiner to think about to avoid potential delays in getting their information uploaded to their state driver's licensing agency. So whether that's through a safety meeting or some kind of email blast or communication you send out on their ELD, doesn't really matter. Just make sure that, first that you have your new processes and policies in check and that you communicate those effectively with your CDL population. For CDL drivers, they should ensure that they schedule their exams well in advance of the current exam or med card expiration to allow time for processing. Again, failing to do so will lead to inevitably violations for operating with either an expired med card or worse, a downgraded CDL because of that med card. So this is not a novel issue. This is something some drivers currently experience. I worry though that it's going to this transition period is going to exacerbate the problem a little bit. So drivers need to be to move forward with caution in that regard. Again, carriers should have processes in place to ensure drivers are timely renewing their med cards and running the required MVRs in time so there are no lapses in the driver's physical qualifications. So when it comes to providing information, maybe internally to your safety folks and then also to your drivers, I'll note that the FMCSA has some good fact sheets available. That's a link. If the Infinity folks are going to distribute the PowerPoint, hopefully that link will follow through. You could click on it and get access to those fact sheets. You can also just Google FMCSA medical certification changes or something to that effect, and you'll get to their landing page where you can download those fact sheets. That would be a good source of information. Some other recommendations. These are coming directly from FMCSA's website, and I think they are good recommendations. CDL drivers should ensure that they have any supporting documents that they need with them during their medical examinations. We see this with drivers with certain medical conditions. The one that seems to come up the most are drivers with sleep apnea or high BMIs or neck sizes, those that end up needing a sleep study as part of their medical qualification process. If they know ahead of time that they're going to need something like that, they shouldn't wait until after their DOT medical exam to go get those things. They should have them available with them to provide to their DOT medical examiner so that there's not a delay on the back end of things. If they have that stuff with them when they go to the medical examiner, then they'll just have it all in place and the medical examiner can go ahead and issue the medical certification if they feel comfortable with it, rather than saying, well, I'm not going to issue your medical certification until you go get a sleep study. Now you got to go, drivers got to schedule that, wait on that, and then potentially have a delay of time before they get the med card. That will run them into issues. Drivers should also double check their information, namely their CDL number that gets written down when they go for their medical examinations, because that CDL number is going to be the key to a smooth transaction. That CDL number is the identifier through which the medical examiner is going to associate that new medical information via their transmission to the National Registry. And if that CDL number gets mistranscribed on however the nurse or whoever is taking that information down, then that's inevitably going to lead to problems. And so ideally, the driver would have their CDL right there with them in the medical exam, and then they would cross-reference however it was taken down by the medical examiner or their assistant to make sure that no numbers were mistranscribed or anything like that. So that's a good tip. For medical examiners, if there's any of those listening here, FMCSA is recommending that you make copies of the driver's CDLs when you are doing the medical exams so that we don't have that mistranscription problem. Take a copy of their CDL so that if there's a problem down the road and the information didn't get transcribed or didn't get transmitted appropriately, or there's errors when you try and submit it to the National Registry, then you can look at your copy that you made of their CDL to make sure you got the number right. And then if a problem does occur and for whatever reason the new medical certification information doesn't get transmitted, then the FMCSA is recommending that carriers and drivers go through this kind of chain of command here. They say that the first thing that they should do is contact the medical examiner that performed the medical examination to make sure that the exam information was in fact transmitted to the National Registry. If it was, and that it was transmitted correctly, in other words, that the CDL number matched and everything like that. If it was, then the driver or the carrier should then contact their state driver's licensing agency to see why the information didn't get associated with that driver's driving record. That's the process to troubleshoot. And then ultimately, if that doesn't work out, then the FMCSA has set up a help desk for this. Judging by Judging by other FMCSA help desks that they have set up and the response times that we know from those other help desks, I wouldn't put much stock or much faith in getting a quick response via this help desk if it were me. But this is the email address that they have set up for problems with this new certification process. This would kind of be a last resort, but again, I wouldn't put much faith in it, unfortunately. What we know, so the FMCSA on that website that I mentioned that they set up, they are regularly updating the list of states that have supposedly implemented the things that need to be implemented to effectuate these changes come June 23rd. This is the list as of today, June 12th, 2025, of states that have a system that will be able to process the results. You may notice that this is only about half the states. There are 26 states on this list. There are 24 states not on this list. Good news is this list seems to be growing every day. It has grown by 5 or 6 over the last week since I first started looking at this. And so hopefully that means that the rest of the states will get their act together here in the next week or so, and everybody will be ready to go. But I am not holding my breath on that, unfortunately. So we'll just have to see. Like I said at the start, some of these states have been doing this for a while now. And so theirs is ready to go, clearly. But some of these other states on here are fairly new. And so their system is probably not tested or vetted very well at this point. All right. And then some frequently asked questions, and then I'll start addressing some of the questions you all have dropped in the chat. But here are some of the most common questions I've been receiving and some of the answers that I've been able to find through FMCSA guidance or talking with my FMCSA contacts. Number one, will CDL drivers still be issued physical medical examiner certificates, med cards, after June 23rd? The FMCSA's response is no, they will not unless they specifically ask for them. Remember, we're transitioning to an electronic process. And so they will not be issued as a matter of course unless the CDL driver asks for them. Along the similar lines, must CDL drivers still have their med cards in their possession roadside? And the answer to that is no. Again, that physical med card, even if they happen to have it, is no longer definitive proof that that driver is medically qualified. It's only the driver's driving record that is proof. So that physical med card is about as valuable as the paper that it's written on going forward. Can physical med cards still serve as proof as a CDL driver's physical qualifications? No. Again, the exam information on the driver's record is the only official proof of that driver's medical certification status effective June 23rd and going forward. Must carriers still obtain physical med cards from CDL drivers going forward? No. Again, the only official proof of that driver's medical certification status is the MVR, is the driving record. So the carriers must run the MVRs as proof that they are medically qualified and then put a copy of that MVR in their driver qualification file. So that should be a process of yours. In addition to your annual MVRs that you're running, you should also have a policy or process in place that anytime a CDL driver gets a new med card, I need to be running an MVR on that driver and making sure that that new medical information is associated with that driver's license. And if it's not, then unless their old med card is not yet expired, you can't use them. So be careful there. That will run you into big trouble if you don't do that process appropriately. And then lastly, must carriers still verify that the medical examiner is on the national registry? This has been a temporary thing that we have, as motor carriers, been having to do for CDL drivers over the last 10 years during this interim period, which is, and some carriers miss this, other carriers do a better job at it. But anytime a CDL driver gets a new med card, you're supposed to be running a verification that the medical examiner listed on that driver's med card is actually on the National Registry of Medical Examiners by typing in their registry number. And usually most carriers will print off a screen that shows that that medical examiner is in fact on the National Registry. That process will no longer be required as of June 23rd, 2025 and going forward. All right. So that was a lot of information to get through. We got about 15 minutes left, so we'll take some questions here. I've seen them kind of going up on the screen. I haven't been watching them, so I'll let Steve or Mark kind of direct me to the ones that they think I should answer.
Sure. Well, first of all, there have been quite a few questions about whether or not they can get a copy of this PowerPoint. And I think, Brandon, if it's okay with you, we'll make sure we include
Yeah.
this with the email we'll send out to everybody that's registered, along with a link to the recording of this webinar. So we'll try to get you covered with all this information. There have been a number of questions, I think, that I've seen about the current process requiring the need to check the MVR after 15 days. Do they now need to do this after 48 hours, or
Yeah,
they
they
can
should do it. They should. There's no timing period now, but the
okay,
idea is that once they get a new medical certification, the only valid proof that they are medically qualified is that MVR. And so, assuming you've got an old MVR that shows their old medical certification status, as long as it's not expired, I think you're okay. But you should have a process in place that says, you know, close to that driver's expiration date, ideally before, but whenever that driver gets a new medical certification, you should be running an MVR because then that's your proof that they are medically certified. If you haven't done that, then you don't have any proof other than the driver's word, which is not worth anything, that he has a new med card. And again, that physical med card that they may give to you is not official proof of their certification status going forward. So that MVR is crucial, and so you're going to want to run that as quickly as possible after they get that new medical certification.
and then I know there have been questions that that MVR then needs to go in the driver's DQ file.
Yeah. Yes.
Okay. Is there any kind of a grace period that's been put out by FMCSA about any of this?
No, we've had 10 years of grace period. So no more grace period as of yet.
Okay. Um, so a lot of people have asked, so the driver is no longer required to carry any kind of documentation. A
CDL
DOT
drivers
officer or
specifically.
somebody, yeah, will
Yeah.
be able to see that on their record,
Yeah,
right?
that's right. Yeah, for CDL drivers specifically, will no longer have to carry proof of their physical qualifications. It will be on their driving record that the officer would run roadside. Non-CDL drivers, on the other hand, still have to carry that physical med card with them.
Okay. Um, there's, hang on a second, there was another question. Somebody asked about, let me, here it is. If a company is on the California pull notice, will we still need to run an MVR? I don't know anything about that.
Yeah,
Brandon.
I don't know enough about it. I know that California has a pull notice program that's essentially kind of an automated MVR for California domiciled drivers that fleets in California have to run. It's similar to continuous license monitoring that some fleets voluntarily subscribe to. I don't know enough about the pull notice reports as to whether they display medical certification information. I assume they do, and if they do, maybe that's sufficient. But I don't want to give an answer because I don't know. I haven't looked at a pull notice report in a long time.
Okay, very good. Mark, did you have any questions? I'm going to look at the chat here
No,
again.
it looks like a lot of responsibility is being shifted over to the medical evaluation team, and I'm assuming they've been in the loop on all this, but that's a big assumption. The other comment I would make that was one of your recommendations that you've got to get this information out to your drivers. I can see a lot of creative interpretations of this, such as, oh, we don't have to have medical exams anymore. And they'll get their advice at the truck stop, of course, and we don't need that to happen. So if there's ever a good custom content, and I'm assuming they can take some of the slides off of this to help develop custom content to get out their drivers immediately, because this thing comes into effect on the 23rd.
Yeah.
Wow, there's some significant changes here. And
Yeah.
I can see the ball being dropped between the medical evaluator and the registry. I can see him just not doing it.
Yeah. I see some questions here. I'm just going to take here.
Sure.
Somebody's asking timing for self-certification. Remember, that's a process I said it's not changing. So nothing's changing about that. CDL drivers are still going to have to self-certify as interstate, intrastate, non-accepted, accepted at the cadence that they do currently, which, as I understand it, is usually with the renewal of their CDL or if they engage in some kind of CDL upgrade or anything like that. So it's not going to be pegged to the new exam. It's going to be pegged to CDL transactions that they complete. Pertaining to DQ files, is a physical copy of their med card still required in the file? No for CDL drivers. Yes for non-CDL drivers. I'm assuming we still need to verify medical examiners are listed on the National Registry. No, that is not a requirement anymore after June 23rd for CDL drivers. You no longer have to verify that they're on the National Registry, because since this is going to be an electronic process that gets uploaded to the National Registry is clearly involved. The reason we've had to do that in this interim gap of time is because we still had the potential that a driver could falsify their med card that they were issued and then try and take it to the state driver's licensing agency. So we had to have a stopgap measure of ensuring that medical examiner was actually on the National Registry, because the National Registry wasn't involved in the results. Now it is involved in the results, so that's why we no longer have to do that. You guys see any more?
Well, here's one that was interesting to me. It says, who's in charge if driver's CDL is downgraded and the driver is out of service at a way station because of a typo mistake of the doctor's office? Does the doctor's office face any penalties?
Well, frankly, probably not. The doctors on the National Registry are held to standards, and sometimes the FMCSA, particularly in egregious situations. We saw this recently. I want to say it was probably 5 months ago or so. There were a couple of doctors that were issuing falsified exams, or they were writing med cards without even conducting exams. And we saw them pulled from the National Registry. They were revoked from it. And all of those med cards, I think there were like 15,000 med cards. Some of you on here probably remember this, that were rendered invalidated because of that. So the FMCSA does drop the hammer occasionally, but it's pretty egregious situations. I don't think typos are going to draw the ire of the FMCSA. And so if the medical examiner screws something up, unfortunately, it's going to be the driver and the carrier that suffer. And so for that reason, that's why FMCSA recommended and why we recommend that you keep tight reins on that process. In other words, drivers should be double checking the information that gets written down about their CDL number, and carriers should be quick to run the MVR and then go through that troubleshooting process that we described earlier.
A lot of states haven't come on yet. Is there a way for people to know when their state is fully compliant?
The only list I've seen
periodically.
Yeah, the only list I've seen is on that FMCSA website. If you just Google FMCSA medical certification rule, you'll find it. It's also in a link on those slides that are going to be distributed. But at the bottom of that page is the list of states that are ready to go, supposedly. And that has been updated every day over the last couple of weeks. So that's where you could go to see whether your state's on there or not.
Very good. Very good. One thing I want to do, obviously, it's been mentioned several times already. It's going to be very important to provide information and train your drivers about this change coming up to make sure that they understand what they're supposed to do. And I'm going to pop a little poll question up on here. Obviously, our service here is to provide a platform for training your drivers. So if anybody out there would be interested on how we might be able to help you get that information out to your drivers and have it documented so you've got a good record that you did provide the driver training, go ahead and answer the question on the poll. And also you can get some recertification points for having attended this through NATME. So if you're a certified director of safety, make sure you let us know that. So while y'all are doing that, let me see if there are any other.
Yeah, I found a couple I can take here.
Go
Somebody's
ahead.
asking, why do drivers have to self-certify at their state licensing agency if they're no longer being presented a physical med card? Keep in mind, those are two separate things. They're kind of related. The self-certification is the driver telling the state driver's licensing agency whether they are subject to the physical qualification standards or not, is essentially what the self-certification is. If they're an intra-state only driver that is exempted under some state exemption from the medical exam, the state licensing agency, unless the driver tells them that, wouldn't know about it. And so they need to know that they are exempted so that then they don't try and downgrade their license based on not having the med card from that driver or from his medical examiner. So that self-certification process is still necessary. And I see somebody else commenting, this is probably right. I'm not familiar with the process in every state, but they said that in some states that self-certification process it can be done electronically. And so it's probably a state by state process analysis. But in any event, that's why it's a separate process, is because it's telling the state licensing agency in the first instance, should we as the licensing agency be expecting a med card for this driver or not? And that will inform how we handle their CDL based on whether we have that information or not.
What happens if the state doesn't come on board by the 23rd?
It's a good question. I don't know the answer to it. I don't think FMCSA is going to delay the rule any further, and but that puts you in a pickle, right? Because if you got drivers domiciled in that state that whose medical exam expires on that date, which inevitably we will have, I don't know how that's going to be handled. Maybe some type of, we've seen FMCSA do this in the past. This is just me guessing, but they may issue some type of an enforcement bulletin that essentially says, and this goes back to that grace period question. It hasn't come out yet, so don't hear me wrong here. But I can envision FMCSA saying, if we have some states who are lingering behind here, maybe we issue a temporary enforcement bulletin that says for 30 days, we won't enforce this requirement against these drivers. We've seen them do that in other contexts. I could envision that happening, but that's just guessing at this point.
I think maybe you already answered this, but drivers still need to go to the SDLA to self-certify?
Yes.
Okay.
Well, unless they're in a state that has an electronic process for that, which some others in the chat have said there are some states like that. So,
okay.
Yeah, but nothing's changing about the self-certification process. Here's another question. Do we need to retain existing med cards in the DQ file for historical or litigation purposes? That's a good question that I don't think the FMCSA has addressed for you, but yes, you should be doing that. So under the normal qualification, the DQ file regulation, there are record retention requirements. For med cards, you're supposed to keep 3 years worth of them in the DQ file. And so I would recommend strongly that you continue to do that you keep 3 years worth of the physical med cards for the drivers to meet that regulation.
Next question. Somebody wanted to know if the medical examiner can charge extra if the driver requests a paper copy.
There's nothing that necessarily
case by case, yeah.
Yeah, there's nothing that necessarily prohibits them from doing that. I don't know that FMCSA would look fondly on that, but because in their guidance, it's just guidance to the medical examiners. It's not a hard and fast rule, but in their guidance, they say, hey, if a driver requests one, you should issue them one. So I don't think they would look kindly if the states start charging for that, but
yeah, that would probably get them kicked off the registry pretty quick.
Maybe not. I don't know.
Who knows? Okay. Seen anything else, Brandon? I'm trying
Just
to
kind of scrolling here.
scrolling through here. Here's a question. So will the previous physical be null and void once the new physical is completed, even though the 3-day process is not yet completed?
Well, that's true even under the current rule, right? A driver gets a new medical certification. It is the official certification. That old one that they had is no longer the active one. So yeah, that's not changing. So once the driver gets a new medical certification, their old one is preempted by that new one.
Okay, good. All right. Well, I think we've come to our hour allotment here, and I know people have other places and things to go and do. One thing, Brandon, I'm going to send you a copy of this chat file.
Yeah.
And the Q&A file. That way, if we've missed anybody and you feel like you can answer their question, I think we answered a lot of these through the course of your presentation.
Yeah.
but there may
If I
be
see any
some
repeated
instances.
questions that we didn't get to, I'll send it to the Infinity folks and they can get it
That
out to
sounds great.
everyone. There's hundreds of messages here, so I'm not going to answer them
Yeah,
individually,
it's
but
going to be difficult. I
yeah.
knew we'd get a lot, but anyway, great information. I hope all this new process works like it's supposed to, and we don't have a lot of technical issues, because it's just going to cause a lot of grief for a lot of folks, but we'll hope for the best. But Brandon, thank you, sir. This is great information. Um, Appreciate you being on.
Yeah.
And those of you that are still with us out there, thanks for joining us. And
Go
look
Pacers.
forward to an invitation coming soon. We're going to talk a little bit about the English language issue too. So there's a lot of real important things going on here in this month. So,
Yes,
Right.
but
I'd
Brandon,
like
thank you,
everybody
sir.
just to send a quick shout out to Brandon, thanking him for keeping us updated on this most important project. It's we appreciate you supporting our industry the way you do.
Sure. Happy to do it.
And again, we do have an English proficiency webinar in a couple of weeks. Is that right, Steve?
Yeah, coming up.
All
Very
right.
good, Brandon. Thank you. Thanks for all of you that have joined. Thanks for all the thank yous that are popping in. Somebody said go Pacers. So that's all good, right, Brandon?
Oh, yeah. Go Pacers.
All right. Thank you all very much. We're going to go ahead and end the webinar. So thank everybody for coming. Thank you, Brandon. Thank you, Mark.
Thanks, everyone.
All right, here we go.